and carry on where we left off. So, any apologies? I don't think we had any, did we? No. So I will move on to conflicts of interest, and I'm going to ask our Chief Executive, Keith Marshall, who's going to come up and speak to us just on this before we take conflicts. I know we have a number of members who are potentially declaring conflicts on a couple of items, or at least one item, and it would be good for us just to have a reminder and for the public around our declarations of conflicts. Thank you, Keith.
So today, and in particular around gambling policy and what we're putting out there, I've sent around an email to all councillors around conflicts of interest. And so this is just an opportunity by way of a reminder about the caution necessary in particular areas around sensitivity. So I guess my general approach to conflicts is we're having a conversation today about going out for consultation. So council's risk around this item is relatively limited. We're not going out with a final decision, we're going out for consultation. But the point here is where there are conflicts of interest or perceived conflicts of interest when the final decision comes into being, it can influence council's final decision. So for example, if we have all 13 of you participating, and the final vote ends up 7-6, there's a one vote in it, and there are some perceived conflicts of interest that weren't declared, and they're challenged through a legal challenge to it, it can invalidate council's decision. It can also expose council to legal action around the decision making. So my caution generally to elected members is if you think you have a conflict of interest, or if you think there should be a perceived conflict of interest, it is over to you to make that declaration and withdraw. Bearing in mind that in the event that, say, there was a decision of council and that there were 13 people voting on it and the final decision was 12-1, one person's vote isn't going to make a difference in that final decision, so there is no harm in declaring a conflict of interest and not participating. You won't influence the decision either way. If, on the other hand, you think your vote will be the influencing decision and it is a tight vote, then potentially you are sinking the decision. So my advice is always around conflicts of interest. If you are remotely in doubt, I'm happy to provide individual advice to you around potential conflicts of interest, but if you are in any doubt whatsoever, take the cautious approach and declare a conflict of interest and don't participate in the discussion. Today's discussion I'm relatively relaxed about because it is just a decision for us to go out to consult with the community and come to a point of view. However, if when that final decision comes back to the table you believe that you might have a conflict of interest, then you are no worse off from declaring that now and not participating at all, because it will come back to haunt you if it is a tight decision of council when the final decision arrives. So just urge you to take an absolutely cautious approach. There's no harm done from declaring a conflict of interest and not participating if the decision was going to be an overwhelming one, either in favour or against your point of view. But if it is a really tight decision or has the potential to make a decision, then not declaring that conflict of interest potentially creates an issue both for council and for you achieving the point of view that you were attempting to pursue either for or against. So the last point I'd make about conflicts of interest is that the Local Government Act is also quite clear about having predetermined views about a matter. Entirely over to you to make the call about whether you think you have a predetermined view about the matter, and it's up to you to assure yourself that you don't have a predetermined view. You can keep an open mind about the matters in hand and can come to a view. The Local Government Act is quite clear on that. For really tense and sensitive issues, and this you can, your friend Google will provide you plenty of examples around the country. When council gets its decisions challenged in these areas of conflicts of interest or perceived conflicts of interest, or for a predetermined view, actually those become extremely onerous situations for individual elected members to look after themselves. You are not covered by your indemnity cover for that. So you will be doing that on your own cognizance. So I guess the thing I'm saying is around your whether or not you have a predetermined view, it's entirely in your hands. You need to be able to look to yourself and assure yourself that you don't have a predetermined view and that you're prepared to keep your mind open. But in terms of conflicts of interest, I would urge you to take undue caution and declare a conflict of interest if you think you have one or perceive one. As I said today around the decision to go out for consultation, I think the risk to council is relatively low because we're merely going out for consultation. But I would urge you to think about a potential conflict of interest because it will come back in the final decision process.
Thank you very much. Is it procedural?
Just a little bit more explanation.
All right, yep.
Just, you can have a perceived conflicts of interest. Can you have a perceived predetermination?
No, I think that there hasn't been a test case yet around predetermined view, but there has been lots of traffic in various court cases, and I'm not going to mention any of them. You can look them up on Google. But there has been quite a bit of traffic where individual councillors' positions have been challenged about having a predetermined view. If I was to take a hypothetical situation, and let's say I was a member of a society who was doing something, and we were coming to a council decision about that, then it could be seen that I had a perceived conflict of interest in voting in favour of what supported the society. But it could also be argued that I had a predetermined view as well. So, again, I would come back to err on the side of caution.
Thank you, Keith. And thank you very much for speaking to that for us. So with that being said, I will call for any conflicts of interest from members on any of the items on the agenda. Thank you. I have one from Councillor Taylor, one from Councillor Price, one from Councillor Crown, and I believe that is everyone. Thank you, councillors. I'll move on to, we have no public forum today. Order, thank you, Councillor Price. And no announcements from myself. Do we have any from management? None from management. So we will move on to confirming the minutes from the future Napier Committee meeting held on the 22nd of October. Do I have a mover for those minutes? Councillor Crown and Councillor Crystal. Thank you. All those in favour, please say aye.
Aye.
Any opposed? Carried. Right. I'd like to welcome Rachel Horton, who is our acting director today and is our manager of regulatory solutions, who will introduce item 1, our review of our gambling venues policy. And just for the public, I would note that is the item that I believe all three members have declared a conflict on. And for the purposes of this debate, they will step back from the table or just not engage. Thank you.
Thank you, Madam Chair. So just before I introduce the paper, I just wanted to draw your attention to an error on page 9 under heading options. It should read that the options available to future Napier Committee are as follows.
Thank you.
Okay, so this is the first report which is introducing a review of Council's gambling venues policy. And I seek your endorsement of the review process and your approval to release the SOP or the statement of proposal for consultation to the public. Councils have a particular role both under the Gambling Act and the Racing Act to control the impacts of Class 4 and TAB gambling on its community. The mechanism for this is through the gambling venues policy, to determine whether Class 4 and standalone TAB venues can be established in Napier, and if so, how many and where. Both acts require a review of this policy every 3 years, and that is why we're here. So to commence this review, officers held 2 workshops to determine Council's policy direction for consultation. Direction was given to remain with the existing policy for consultation, which would mean a continuation of the status quo in regards to the number of machines, the venues allowed, and where they may be situated in Napier. So that means that we would be consulting on retaining the cap of machines at 320, 20 venues, 3 in Taradale, and 2 TAB venues. We would also be looking to retain the relocation and club merger policies within the policy and retain restrictions on new or relocated venue locations. Other options for council to consider consulting on are set out in Table 1 on page 4, which is we can lower cap amounts. That is, decrease the number of venues and or gaming machines. A capped approach means that every time a venue closes, the number of permitted machines remains the same. This means that other venues can apply for additional machines if the permitted number of machines hasn't been exceeded or if a new venue is established. So the council's current cap is at 320. We currently have 298 operating in Napier. Another option is to adopt a sinking lid policy, that is to decrease the number of gaming machines or Class 4 venues through natural attrition. It bans any new gaming machines or venues, and if a venue closes and a licence is not taken up within 6 months from the date of closing, then the machines in the community are lost. The sinking lid policy does not reduce the number of machines in an existing venue that is operating. You also have options to remove the relocations and or mergers option within the current policy. That is, in addition to any of the above, you can consider whether to remove the ability for gaming machines to be relocated and the ability for clubs to merge machines. This would prevent two clubs merging and having a large number of machines at one site. Currently, Napier has 4 clubs operating 63 machines in total. So as part of the progress for this consultation process, this paper was given to the Māori Committee and to consider and make recommendations to council, and I draw your attention in the paper to their comments that council should consider adopting a sinking lid approach as the preferred option for consultation. Following the meeting today, you will have the second debate at council meeting on the 17th of December, and that's to consider and make the decision on the adoption of the draft policy for consultation, including the statement of proposal. We'll then enter a consultation phase early next year from 18th of January to the 17th of February, and that's invoking the Section 83 Special Consultative Procedure, which will then, after following, will be a hearings meeting and deliberations, and then finally a council meeting next year to determine the final gambling venues policy. Finally, council's role in reviewing its policy on gambling venues is to have regard to the social impact of gambling and balance the harm of gambling with the social benefits of allowing Class 4 gambling within Napier. This paper is to commence public consultation on the matter, which is only the start of the policy review process. Consultation, however, is council's opportunity to signal and lead a discussion on a preferred proposal, and that's for your decision here today. Thank you.
Thank you, Rachel. So what we'll do is we'll have questions followed by discussion, and then we will carry forward in that way. Do we have any questions of officers? Councillor Brown.
Kia ora, Rachel. The consultation, when it goes out to the public, it obviously includes our preferred option. Does it also include the other options that are available to us? Will we be putting that information out into the public arena?
Yeah, the statement of proposal does set out the other options that council considered when they developed their statement of proposal. So it sets out the advantages and disadvantages of each of those options that council considered.
Okay.
Thank you. Are there any questions? Maybe we'll move into discussion.
I will ask a question.
Mayor Wise.
Okay. And this is probably for me a question of clarification, which was something we discussed at the workshop, and I'm just wanting to gain a better understanding of. We had quite a discussion around the ability in our current policy to relocate the machines if you held a licence. And at this point in time, we do permit that. And there was some concern raised about an existing business potentially wanting to move down the road. It would restrict their ability to, for commercial reasons, move premises to perhaps take advantage of lower rents, etc., or something like that, which was sort of probably the predominant driver for us deciding to keep that particular clause as is. Would there be, is there the ability to actually have a provision whereby, as a standing rule, relocations are not permitted, however, there is an opportunity to apply for an exemption which would cover circumstances such as what I've just described?
Yes, I think you could provide for that in the policy if you were clear about the process and who would make that decision. Yeah, and what would be, under what criteria would you consider an exemption? You'd have to be quite clear about what it is and what it isn't. Yeah.
Okay, which I think you could build, some quite clear guidelines around when that exemption could be applied for and in what circumstances it would be approved. Thank you.
I'll follow on with a question. One of the things we discussed, I suppose, at length in the workshop on this topic was the harm that gaming machines obviously have to a smaller proportion of users of the gaming machines. And just to, I suppose, clarify, all of the evidence and science that we have points to the fact that the number of gaming machines and the number of venues doesn't necessarily, if you were to decrease those, doesn't necessarily become reflected in the numbers in terms of gaming harm. Is that my understanding correct?
I think when you go through your consultation process, you will get differing views on that from different people who may be advocating. I think it would be better to wait to hear that evidence from those parties. It's not for me to make a judgment on that.
Thank you. Councillor Simpson.
Thank you, through you, Madam Chair. Just to follow up from Her Worship's question around process, if we were to seek to put that sort of context within the policy, do we need to do that between now and the consultation, or can we do that after the consultation, or what would be the appropriate way of approaching that sort of change?
I think it would be best for you to seek public views on that. So yes, I think it would be best to signal it in your statement of proposal, so that everyone has an opportunity to comment on it.
Okay, so we don't need to change the draft policy, but we include a statement in the proposal.
The statement of proposal is a redraft of the policy. So yes, we would be looking to, you'll see in the papers here that we have included a draft policy, and any changes are marked in red so that the public can really see what it is you're proposing to change in your statement of proposal.
Cool. Thank you. Does anyone else wish to speak? Questions or discussion before I ask for a mover? Okay. With there being none, I'd like to call for a mover. Councillor Mawson. And seconded by Councillor McGrath. Councillor Mawson, would you like to speak to the motion? Okay. Councillor McGrath. Okay, I'll open the floor. Does anyone else wish to speak to the motion? So just to clarify, we have moved the officer's recommendation. So we're noting the information, endorsing the review and approving the statement of proposal, which includes our status quo preferred position. Mayor Wise.
Yes, I will speak in support of the motion, and we have discussed this at length in our workshops. And the decision to go out with the status quo really was because we wanted to go out and give our community the opportunity to provide us with their feedback, to make submissions to the consultation process. And we just felt that the information that was in front of us at the time, there wasn't conclusive evidence to support that a reduction in the number of machines and venues would necessarily lead to a reduction in the gambling. And I'm really looking forward to actually hearing from our community, hearing their views. And we've also asked, as part of the consultation process, for other ideas and other input from our community about other ways that we as a council could be working towards reducing gambling harm in the community. So that's just to provide a little bit of context from my perspective of where we, how we arrived at the decision to go out with a status quo statement of proposal.
Thank you, Mayor Wise. And can I just ask a question? Your earlier commentary around potentially exploring exemptions to the mergers and relocations, is that something you would like to propose that we include in the statement of proposal?
That is something that I would like councillors to contemplate and perhaps for us to explore before we come back to the double debate, so obviously have that conversation with staff as well. For me personally, I completely agree with Councillor Simpson in terms of there's definitely, I think, circumstances where it's appropriate and we should be allowing a relocation. However, at the same time, I would be quite keen to restrict circumstances where you do have a venue closing completely and a business owner sees an opportunity to purchase the licence to then take those machines and have them at another venue somewhere else within a city. That is something that I would like to have the ability to prevent from happening.
Okay, so if we can just make a note of some further information to come back to council, possibly before the meeting, so if it is something we wish to pursue, we can build that into the final statement of proposal. Councillor Boak.
I would like to speak against the preferred option outlined in the paper. Unfortunately, I wasn't present when the workshops were conducted, or the second of them, when the suggestion was made, the direction was given for this particular paper. So I'm going to also foreshadow, if this motion fails, I'm going to foreshadow that the draft policy to go out for consultation is the sinking lid and lowering the cap in the existing number of machines. But first of all, let me explain why I do not support the chosen option going out. The decision we have to make today is to, and I quote from the paper, to consider what policy position we wish to take during this review to continue to reduce the harm from gambling within the community. And from the information provided in the paper, I don't see how our current policy has reduced harm from gambling within the community. Under the current policy, as it said in the paper, pokies gambling has increased in Napier by 17.7% between 2015 to 2019. Napier is currently the 7th highest in all territorial authorities nationwide in terms of our loss per head to pokie machines. Last year we lost $107 per head to pokies. In comparison, Hastings lost $76 per head. So what that says to me is that our current policy, the one we're sending out, has not done what we're asked to do here, which is reduced harm from gambling within the community. Perhaps it has. Perhaps that's what we'll hear from the community coming to speak to us. So another issue that I'm concerned about when we take this position out to the community is that we are a safe and Napier city. We are accredited to reduce harm in our community, and one of those harms is addiction-related harm. And a question we need to ask is, does our current policy, which this recommendation is sending out as the council's preferred option, reduce gambling harm? We will hear that from our community. The Māori committee asked for their input, and Māori and Pacific people are most adversely affected by pokies gambling. So their suggestion was they rejected the current policy and they want the sinking lid policy to go out in this paper. So for all those reasons, I'm not convinced that we should be endorsing the status quo as our preferred option, which this paper is doing. It may be that, you know, a sinking lid and lower cap, which I want us to discuss, won't reduce harm from gambling, but I think it's worth a try. So I urge you to vote against this resolution.
Thank you, Councillor Bogue. Yes, you might want to reserve your right of reply till the end, but you're welcome to have your first speaking position. No, you're welcome to speak first.
You get to
Because you were
speak
the
twice.
you were the mover. You
No,
haven't spoken yet.
That's okay. So, I mean, my position would be, I just endorse the Mayor's comments earlier. And I mean, although problem gambling is a serious issue, the evidence that I've seen suggests that once identified and help is sought, that problem gambling can be effectively and promptly treated.
Thank you, Councillor Mawson. Are there any other comments? Councillor Tapney.
Thank you, Madam Chair. So I'll be speaking against the recommendation on the table for very similar reasons to Councillor Bogue. Notwithstanding the comments from Her Worship Mayor Wise, I initially, when we went through the workshop, had exactly the same reservations. I would have preferred to have been approaching this conversation with our community based on good data that had good integrity behind it and showed that whatever actions we'd done in the past provided positive outcomes. Unfortunately, we have no control of how that data is put together. It's presented to us in the form that it is, and our staff do the best they can to interpret that. But there are a whole lot of other lenses that touch that data before it even gets to our staff. So I don't think I'm going to find the answers I'm looking for in the data that's coming from this sector of the community. So the reason I'm voting against the recommendations on the table at the moment really, for me, harkens back to the PJ and Pettigrew Green Arena. I know we don't have all the facts and I know we don't understand all the full impacts, but we would like to send out a consultation document to our community. As I think back on the first item today, we didn't have all the facts. But more than one councillor said that we need to lead and we need to, this was a no-brainer, that the court situation required an action on behalf of council and we needed to stand in a position and lead in that regard, despite the fact we didn't have all the data. Now, I know we don't have the quantifiable data to help me feel comfortable with where we might head, but I would like to see this council actually lead from a position rather than step back or abdicate, and that's not a criticism, it's just my viewpoint, rather than step back and advocate that as an elected member, I'm just going to let the community make that decision. So we didn't take that stance with the Pettigrew Green Arena. So from my perspective, I think the results are the same. If we were to lead out with a statement saying we'd like a sinking lid, then the community can come back and say, actually, we think you're out of step. The alternative currently is, let's just sit back, leave the status quo as it is, and ask the community to lead us into this conversation. And there are pros and cons for both. But my position and the reason why I'm voting against this recommendation is I was elected to lead, to make a decision, and accept the chastisement or the encouragement from my community, come what may. I did look at this item and try and find a premise based on the data, but it didn't really help me. So those are the reasons why I would like to see, or well, I'm speaking against the recommendations on the table.
Can I just have a point of order, please,
Yes.
Deputy Mayor? I did not state that I was wanting the community to make the decision. My basis of supporting this is that I want to get more data. We know for a fact that we will have organisations submit to this consultation process who have sound, robust data, and I want that in front of me to guide our decision making. Thank you.
Cool. Thank you for that correction, Mayor Weiss. I'd like to open it up to any other comment from members before we put this motion to the vote. Councillor Brown.
I suppose I'm a little uneasy that we're with the wording in terms of our preferred option. I think I too, like the Mayor, would like to hear what the community think, and I don't know if it's possible, but I would have preferred all the options be put to the community and hear what they said rather than us sort of, it feels like we're quite strongly going out with this is where we would like to lead. But so I think I'm okay with it in general that all of the information is put forward in front of that, but yeah.
Thank you. Is there a member of staff who could potentially speak to our Section 83 requirements around options in a consultation?
I'll give it a go. So just a addressing yours, Councillor Brown, the requirement is for us to consult on something. So we have to have a statement of proposal that we consult on and ask the community what they think about that. And so all of our consultation follows that form and function of preparing a statement of proposal to go out and consult on. Section 83 under the Special Consultative Procedure is the manner and form in which we do consult, that we have to identify all affected parties that we can, that we have to provide fair opportunity for all parties to have their say, that we have to provide, that we have to signal, the type of proposal that we're putting out there. Trying to think what else Section 83 covers. There's a lot in there, but basically it's the fairness and the robustness of how we consult, who we consult with, and the timeliness in which we do it. And it's quite prescribed, and what you have in here in terms of a review process ticks all the boxes for Section 83.
Thank you.
And just, but I see your hand, thank you, Councillor McGrath. And just before we move on, I think Section 83 doesn't require us to state it as a preferred option as well, and we note that in the actual consultation document that we won't be calling it a preferred option necessarily. Is that correct? Rach?
Just through the chair, I can answer that one, because Section 83 is about the special consultative procedure. It's not about the matters that you're consulting on and the options around it. Section 83 is just about the process, about how you go and involve the community.
Are you best placed to answer that question around whether we need to call it a preferred option in the public forum, Adele?
If you just give me a couple of minutes, I'll look into that now.
Okay, we'll come back and follow on from that question. Thank you, Councillor Brown. Councillor McGrath.
Yeah, just can I start with a question through the chair? Historically, have we had more machines in Napier than we have now? Does anyone know that?
Yes, we have.
We have. Okay, so we have data from, we have historical data that as city leaders, we're making our decisions from at this stage. So to say be brave, I think, or what have you, we've actually had a lot of information in front of us, both this time and previously, that I feel quite comfortable and support the motion that we can go out to the public based on the information that we have here.
Through you, Madam Chair. We've had more machines in the past in venues, and we've had less machines in venues in the past. We've had an increase in the number of game machines in venues just recently. I'll try and find that in my report here somewhere.
Sorry, just a follow-on question from that, if I may, through the chair. Am I correct in my understanding that we currently have the maximum number of venues at full capacity? Therefore, there wouldn't actually be any ability currently for the addition of any machines on top of the 298 that we have?
Yes, we have we have 20 venues. We have 298 machines, but the allowance for 320 machines. What I can't answer is whether all of our venues have reached their full capacity of machines. I think they have at 9. But if there were any venues that hadn't, then arguably they could increase the number of gaming machines.
My understanding is I think they're all at their maximum, but yeah.
I'll just go back to our Director of Corporate Services, Adele Henderson. I believe you're answering the question we had earlier from Councillor Brown.
And through the chair, so just in regards to the Section 83 section, it is a statement of proposal, so it doesn't need a preferred option. If you're consulting under Section 82, you do have to consider all practicable options with a preferred option, which is your normal sort of long-term plan type process. But when you've got a statement of proposal and looking for feedback, you don't have to put out a preferred option.
Thank you. Councillor McGrath, did I see your hand before? No. All right, there being no further speakers.
Sorry, could I just ask another question along those lines? So we don't have a preferred option in this paper? Is it all just going out?
You
as
have a
take your
statement of
pick?
proposal.
And does a statement proposal recommend a particular option? Or is it just take your pick of the 4?
The statement of proposal, your proposal is that you remain with the status quo. Yep.
So there is a preferred.
I'll take Councillor Brown and then a question from Councillor Tape.
So the statement of proposal, that is the document that goes out, or is it?
Yes,
Yeah.
the attachment.
Yeah. So on the bottom of page 13, that's where it says preferred option for consultation.
So I've got on your attachment B, page 12, is your statement of proposal, and this was what would go out to the community together with any amendments to the current policy, which is also attached, and amendments have been track changed, and they really are just typo sort of amendments. So the members of the public would get your statement of proposal plus a draft gambling venues policy, which is what you're proposing to be the policy.
Councillor Brown, are you saying you found the word preferred in there?
Oh, yes. On the bottom of page 13, in the heading where it says in the table, the option 1, status quo, and then brackets, preferred option for consultation.
So if we could just note a change to proposed rather than preferred, as per that previous discussion.
Yeah, that would make me feel a lot more comfortable. Thank you.
Okay, thank you.
Well, if it's a status quo, it wouldn't have to be preferred because it is what it is.
Preferred for consultation. All right, Councillor Mawson, you have the offer of your right of reply. That's fine. Right, so I will put the motion, and just for clarity, I will read that. So that is item 1, and the officer's recommendation, which was that we note the information relating to the review of Council's gambling venues policy, that we endorse the review process, including the approach to consultation, as set out in our significance and engagement section, and that we approve the statement of proposal for public notification through the special consultative process, as prescribed by section 83 of the LGA. I will put that motion. All those in favour, please say... Oh, sorry, I have... Yeah, I think we'll just make a note of it because it's coming back through double debate, and we will adopt it with amendments at that stage. Thank you. All those in favour, please say aye.
Aye.
All those opposed? No, I had a hand and a no. So the item is passed. Thank you. And just for the record, those voting against were Councillor Tapani and Councillor Bogue.
I think it's standard.
Yeah, I think we record all votes against. All right, we will move on to item 2,
Sally.
which is the review of the location of the approved psychoactive products sales points policy. Rachel, are you presenting this one again? Thank you.
I am, thank you. So similar to the gambling venues policy, this report introduces the review of the Council's approved psychoactive products sales points policy. by seeking your endorsement of the review process and the approval to release a statement of proposal for consultation. So the core purpose of the approved psychoactive product, the core purpose of the Psychoactive Substances Act is to regulate the availability of psychoactive substances to only those people over the age of 18 and to protect the health of and minimise harm to those who use them. The Act allows Council to implement a policy relating to the safe approval of products within its district. Under the Act, local authorities are empowered to develop a psychoactive product sales points policy. Council can't prohibit the sale of approved products. A policy does enable Council, however, after consultation with its community, to restrict the geographical location of selling psychoactive products within Napier area, including their proximity to other premises selling such substances, and their proximity to premises of a particular kind, for example, kindergartens, early childcare centres, schools, places of worship, or other community facilities. These policies are required to be reviewed every 5 years. Since that, I must say that there are currently no products have been approved for sale in New Zealand for psychoactive substances. These substances are approved by the Ministry of Health. There is also no applications have been made to the authority for licence to sell approved products either within the Napier area or anywhere else in New Zealand. So this policy is in case any such substances were approved for sale in New Zealand. The current policy that we have is pretty simple. It restricts selling to the inner city commercial zone, and there's a map attached to the policy. That sale must be 300 metres apart from each other and 100 metres from any childcare centre, school, library or place of worship. Again, we held workshops with council to determine policy direction for consultation. Policy direction was given to strengthen the purpose and the clause relating to the distance required from sensitive communities to ensure that the exposure to the selling of approved products and their potential harm is minimised across all vulnerable and sensitive sections of our community. So we've broadened the current policy and included an amendment which now includes the wording to restrict the sale with 100 metres of any existing area where vulnerable members of our community and sensitive communities congregate, and includes early childhood care centres, schools, libraries and places of worship. Again, this review requires for us to follow the Special Consultative Procedure, Section 83 of the LGA. And this policy will track along the same timeline as the gambling venues policy, and that is it will council meeting to approve the statement of proposal for consultation on the 17th of December, consultation between 18th of January and the 17th of February, hearings and deliberation in March, and a final council meeting for final decisions on the policy. Thanks.
Thank you, Rachel. Any questions or discussion on the paper?
Oh, sorry, I should mention that, again, also the Māori Committee did make a comment on this paper. And their comment is that they would like to increase the distance to sensitive or vulnerable members or sensitive communities to 200 metres from 100, which is in the current policy.
Thank you, Rachel. Did I see a hand? Councillor Brown.
Just the map that you've included, could you explain the key for us and further to that, I'm assuming when it goes out for consultation it will have a key for the people. So what does the green and the purple mean?
I'll have to come back to you. I don't know what it means. What I can say to you is that I have mapped, and I can pass this around, I've mapped what a 100 metre radius within that inner city commercial zone looks like. And I've mapped what a 200 metre radius in that commercial zone looks like for you to understand how that looks.
Can I just, from looking at that map, I think you've taken it from a parking map, and those highlight different parking unrelated to the bylaw itself.
Yeah, this is the existing policy, and I would have to check that, and we would get a better map.
Thank you. Any further question or discussion?
Yes, sorry,
Councillor
through you,
Simpson.
Madam Chair. Rachel, just to clarify, currently there are some of these vendors, I think, are in some of our other suburbs, but this policy would mean that they can only operate in the CBD, is that?
The current policy is they can only be in their inner city commercial zone, and then they must follow those distances.
Yep. Okay, cool, thank you.
Rachel, can I just ask a question of clarification, which is pulling on my memory from when we first implemented this policy. As I recall, just speaking to the Māori Committee's proposed extension of those setbacks, thank you. The Act requires us not to prohibit and I believe at the time there was some guidance our regulatory team referred to, that if you were to prohibit just down to one venue within your policy, then that in itself would be essentially prohibiting competition. And the way that our city and the zone is set up, with all of the setbacks from each other and from places of worship in particular in the CBD, we could not have more than 2 venues, was the measurements that I recall. Are you able to make comment on that?
I'm looking at the map with the red circles on it. Depending on where those venues were located as to whether they would overlap current red circles or whether they would create space for a second venue.
These are the setback circles.
Yeah, so where there is no red is where a venue could be placed. So if a venue, for example, was placed on the right-hand side of that map, then potentially another venue could go on the lower left of that map.
Yes, so we could potentially have no more than 2 venues, bearing in mind they of course create their own red dot when they're put in. Councillor Crystal.
Just, when you look at this red map, obviously the Marine Parade doesn't have it, and we have a whole lot of playgrounds on the map, which to me is a huge portion of young people around, just like a kindergarten and things. So should it include playgrounds like we have?
It's a decision for you.
Yeah.
Yes, you can include that in your policy if you wish.
Bearing in mind, Councillor Crystal, we have the actual zone that they're allowed, not extending up that
so it's
far.
not- Yeah, I see.
Are you able to
I've
make
got
any
a question.
further comment, Rachel, on setback from playgrounds in the policy? Is there?
I think that if we, playgrounds is a good example, but equally, someone brought up in my team the other day timeout zones and other places in which young people congregate. And where do you stop? We've already broadened the policy to, where it's subjectively we can determine whether it's a place that is a sensitive community or where vulnerable people congregate. So we've broadened the definition of the location. I think that's protection. The rest are just examples of the sorts of places that you might consider to be sensitive communities or where vulnerable people work. So otherwise you might be prohibiting the sale by virtue of actually excluding every place.
Awatara's looking good.
Just a couple of questions.
Yes,
Councillor
Councillor
Bogue. When was the last time any psychoactive substances were sold in Napier? Do we recall?
I don't know about Napier, but I believe synthetic cannabis was the latest type of drug that was sold under this Act, and there was an amendment to this Act to cover synthetic cannabis.
So synthetic cannabis, of course, as we know, is still being sold illegally, but there doesn't seem to be any indication from the government to enable this to be sold legally, or it just seems rather...
So this is just for approved substances, so...
Yeah, and they haven't approved substances for some time, or have they?
We did
No.
have this.
And the other question is, this is a recommendation of the Māori Committee?
Yes, it is. They didn't have the map, so I've done
okay,
that to
I was
help
going
you
to ask
understand
that.
what that might look like if you were to take that on board.
Thank you.
Councillor Tuffney.
Thank you, Madam Chair. So my question follows on from Councillor Bogue's. If the current standing is that we've limited any potential sales to the central business district, and if we were to employ or include the recommendations from the Māori Committee, which gives us this blue map, to me that reads like a catch-22. Are we able to do that? No. Okay, so we can't follow up on the recommendations on the Māori Committee in this case.
No, I think their intent was to try and limit, or increase the distance from these sensitive areas, but they didn't have the blue map, so they probably might not have understood the actual effect of what 200 metres might look like.
But would it be reasonable to assume that they would like to see no spaces available for psychoactive substances?
They haven't made that
Okay, thank you.
recommendation.
Okay, if there's no further discussion, I'll ask for a mover. So Councillor Mawson and Councillor Wright. Councillor Mawson, speak.
Yeah, as we know, and that has been mentioned a few times, that there isn't any substances currently for sale, but I do think we need to continue to have this policy in place, and just in case there is something that does come out on the market, we want to limit harm in those communities and vulnerable people.
Thank you, Councillor Wright. Does anyone else wish to speak? There being none, I'll put the motion, so that being the officer's recommendation, that we note the information relating to the review of the approved psychoactive products sales point to policy, endorse the review and approve the statement of proposal. So all those in favour, please say aye. Aye. Any opposed? Carried. Thank you. I'd like to welcome up Luke Johnson, who is going to present our final paper for us, which is the resource consent activity update. Welcome, Luke.
Thank you. Good afternoon, everyone. Since our last meeting, last committee meeting, we haven't had a great deal of significant applications being submitted to the resource consenting team. However, we have seen a 25% increase in the number of resource consent applications in comparison to the same time last year, which is up from 63, up to 76 from 63. Those applications have ranged from residential, commercial and industrial in nature. To provide you a summary, as you can see in the summary table, there's only one new significant application received, and that was for 62 Raffles Street. The applicant for that has submitted a Section 127 application to vary the original resource consent for the purpose of reducing infrastructure contributions. That's currently under assessment. It's been referred to internal teams for comment and their feedback to the planner that's undertaking the assessment. The other applications, as you can see, for Willowbank Avenue, which has been previously reported to a number of committee meetings, that's been suspended and that remains the case. 262 Emerson Street, again, that has also been previously reported, and that is also currently suspended by the applicant. 121 Battery Road at Ahuriri, that development for the 10 new residential dwellings and subsequent subdivision has been approved, and 72 West Quay, the mixed-use development down there has also been approved. I'm happy to answer any questions regarding those.
Thank you, Luke. Just one from me. Is 62 Raffles Street, is that inside the zone that we have put in a policy for financial contribution reductions?
No, it's outside of that area for the reduction, yeah.
Okay, thank you. Are there any questions? Councillor Price.
Just on the 262 Emerson Street, you say the applicant's suspended. Have they pulled out of wanting to do the alteration, is it?
No, at this point they were waiting on, at the time that I wrote this report, they were waiting on some feedback from Heritage New Zealand.
They've got that though, haven't they?
They do, yes.
Okay. Thank you.
Through the chair, it may actually be the case that that has subsequently been approved now on reflection. At the time that I wrote this report, it had been suspended for that purpose.
Thank you, Luke. Councillor Wright.
Just a query around Group 1 heritage buildings and the other heritage building listed here. Do we have to get permission from any other organisation to approve the demolition of heritage buildings in any category?
For Group 4 items, yes. For Group 1, no. We generally obtain feedback from Heritage New Zealand. They'll advise the resource consenting planner on what their what their preferred outcome is with respect to that.
Thank you.
Thank you.
If I could
Councillor
ask a
Bowe.
question, is that the old bowling club, that property?
At Emerson Street,
No, sorry, Battery Road.
at Battery Road, yes it is.
Okay, thank you.
Okay, if there's no further questions, I'll ask for a mover that we receive the report. Councillor Crown, seconded by Councillor Tapani. Any discussion? There being none, all those in favour, please say aye. Aye. Any opposed? Carried. Thank you, Luke. I'd now like to move that we move into public excluded for the future Napier Committee. Do I have a mover for that? Councillor Brown and Councillor Mawson. All those in favour, please say aye. Aye. Any opposed? Carried. Thank you. We'll move into PX.